Right, disclaimer. Under Title 17 U.S.C. Section 107, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is permitted by copyright statute that might otherwise be infringing nonprofit, educational, or personal use, tips a balance in favor of fair use. Okay, you guys, I found this interesting. I was listening to a Law and Order, not a Law and Order, I love that show though, the Law and Crime YouTube channel yesterday regarding it was a sexual abuse case. I can't remember the details right now. Oh, yeah. It was something, I believe it was one of the Diddy cases, I think. Or I can't remember. It doesn't matter. I can't remember what it was exactly. But this came on my radar. Premises Liability Law. And this is from Justia. So in other words, if certain crimes happen, like sexual assault, rape, physical assault, etc., the property owner has a liability in this. Premises Liability Law. A premises liability lawsuit holds a property owner, Scientology, responsible for any damages arising out of an injury on that person or entity's property. In all states, owners that occupy a property must make a reasonable effort to maintain a safe environment for visitors to it. Failure to keep the property safe for visitors results in premises liability. Common situations that may give rise to premises liability lawsuits are animal and dog bites, slip and fall accidents, dangerous property, negligent or inadequate security, swimming pool injury, inadequate maintenance, children on property, retail store liability, restaurant liability. What about injuries at apartment complexes or commercial property that is merely leased? Usually a landlord is not responsible for the injuries of a tenant's guest because the tenant is presumed to be in control of the condition of the property. However, there are exceptions such as for latent defects, which are concealed and dangerous conditions already existing when the tenant takes possession of the property. Another exception occurs when a landlord undertakes repairs for a tenant. The repairs must be performed in a non-negligent manner. Just want to add in there, what I had seen was it was cited regarding someone being sexually assaulted on, I believe it was P. Diddy's property. So that's something to look into. Different states follow different rules about who may recover for premises liability under which conditions. Some states focus on the state of the person visiting the property to determine whether liability is appropriate. The status of a visitor in those states is usually invitee, licensee, or trespasser. An invitee is someone invited onto a property for a commercial purpose, such as a customer at a mall. A social guest or licensee is also present on the property at the invitation or by permission of the property owner or occupant. You know what this reminds me of? All these women that have been sexually assaulted in the predator's or perpetrator's home. Young ladies, or even as far as that goes, young men. When somebody invites you to their property, I would say 99.99% do not go. Ever. 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 If they want to meet you, they can meet you in a public place. Facts. An invitee is someone invited onto a property for a commercial purpose, such as a customer at a mall, a social guest, or licensee is also present on the property at the invitation or by permission of the property owner or occupant. For invitees and licensees, the invitation is an implied promise that it is safe to be on the property. In some states, a different duty of care is owed, depending on whether a visitor is an invitee or licensee. But in other states that recognize these distinctions, the highest duty of care is owed to both. Invitees versus social guests, licensees. Wouldn't that also be covered under people who were invited to parties? It's just something I was thinking of. Invitee, an individual invited onto property for commercial, okay, that's different, for commercial or professional purpose. Maybe like a real estate guest or something. Social guest, licensee, okay, a party guest. An individual invited onto property without a mutually beneficial commercial or professional relationship. Like a party. In many states that focus on the status of the visitor to evaluate liability, trespassers who are on the property without any right to be there and who are hurt are unable to recover at all. The owner or occupant must simply refrain from intentionally trying to hurt the trespasser, such as by setting traps. However, in some cases, when an owner knows it is likely there will be a trespasser, it is required to give reasonable warnings of non-obvious dangers to trespassers. Usually the exception to this rule is a child trespasser, who may get involved with an attractive nuisance, like a swimming pool, and thus is owed a higher duty of care. In other states, courts focus on the state of the property and owners' and visitors' actions. Generally, property owner and occupants owe a duty to keep property reasonably safe and make repairs for all visitors, except for trespassers. Factors that are considered when determining the duty are the circumstances under which the visitor came onto the property, the nature of the property, the reasonableness of the owner or occupant's actions to repair or warn, and the foreseeability of the injury. I see a lot of landlords not following any of that. I've got a good landlord, so. An owner or occupant must regularly inspect the property to find dangerous conditions and either repair them or put up a warning so that lawful visitors are not injured. Any owner that fails to meet this duty, such as by knowing of a dangerous condition and failing to warn visitors, can be held liable for visitors' injuries that result from it. Limitations on recovering for premises liability. Most states follow the principles of comparative fault in premises liability cases. This means an injured person who is partially or fully responsible for what happened cannot recover for damages arising out of a dangerous property condition. A visitor has the duty to use reasonable care to keep himself or herself safe. To the extent the visitor fails to use reasonable care, the recovery can be reduced by his or her percentage of fault. A visitor's duty. Visitors have a duty to take reasonable care to keep themselves safe on another party's property. For example, in a state following comparative negligence, when an injured person is 10% responsible for an injury, the property owner is responsible for 90% of the injury, and the total damages are $100,000. The victim's recovery will only be $90,000. In states that follow contributory negligence, the plaintiff may be unable to recover at all if he or she is found even slightly at fault. So that was interesting. They've got a whole bunch of information here. Child injury law, I'm going to have to check that out. Legal malpractice, medical malpractice, nursing home abuse. I'd be interested about the child injuries. What about if the child is living on a premises? slip and fall accident law. Also kind of interested in, the blue building. They're not following any of the ADA requirements. And who pursues those building codes that are not being followed over there at the blue building and the other various buildings that are surrounding there, to include a school. Isn't that wonderful, you guys? So I'll leave the link in the description box. Like and subscribe if you choose. Otherwise, have an amazing day or night wherever you are. Peace.